Okay, I'm reading Rimkus Consulting Group versus Inc. versus Cammarata. And this was a Southern District of Texas district court case. The district judge is Lee H. Rosenthal. Spoliation of evidence, particularly of evidence of electronically stored information, has assumed a level of importance and that raises grave concerns. Much of the recent case law on sanctions for spoliation has focused on failures by litigants and their lawyers to take adequate steps to preserve and collect information and discovery. The spoliation allegations in the present case are different. They are allegations of willful misconduct, the intentional destruction of emails and electronic information at the time when they were known to be relevant to anticipated or pending litigation. Those are the allegations. The allegations include that the defendants concealed and delayed providing information and discovery that would have revealed their spoliation. The case law recognizes that such conduct is harmful in ways that extend beyond the party's interests and can justify severe sanctions. Part 1, the pending motions. In November 2006, Rimkus Consulting Group, Rimkus, was sued in Louisiana State Court by Nikki G. Cammarata and Gary Bell, who had just resigned from the Rimkus office in Louisiana. Cammarata, Bell, and other ex-Rimkus employees had begun a new company, U.S. Forensic LLC, to compete with Rimkus in offering investigative and forensic engineering services, primarily for insurance disputes. And next page. In the Louisiana suit, Cammarata and Bell sought a declaratory judgment that the forum selection, choice of law, non-competition, and non-solicitation provisions in agreements that they had signed with Rimkus were unenforceable. In January and February 2007, Rimkus sued Cammarata and Bell in separate suits in Texas, alleging that they breached the non-competition and non-solicitation covenants in their written employment agreements and that they used Rimkus's trade secrets and proprietary information setting up and operating U.S. Forensic. U.S. Forensic is a defendant in the Cammarata case. The Texas Cammarata and Bell cases were consolidated in this court. Rimkus moves for sanctions against the defendants and their counsel and asks that they be held in contempt. Rimkus alleges that the defendants and their counsel conspiratorially engaged in wholesale discovery abuse by destroying evidence, failing to preserve evidence after a duty to do so had arisen, lying under oath, failing to comply with the court orders, and significantly delaying or failing to produce requested discovery. Rimkus asked this court to strike the defendants' pleadings and to enter default judgment against them or give an adverse inference jury instruction. Rimkus also seeks money sanctions in the form of costs and attorney fees it incurred because of defendants' discovery abuses. In response, the defendants not acknowledge that they did not preserve some arguably relevant emails, but argue that Rimkus cannot show prejudice because the missing emails would be merely cumulative of the evidence already produced. Part 2. The framework for analyzing spoliation allegations. In her recent opinion in Pension Committee of the University of Montreal Pension Plan versus Bank of America Securities, the Southern District of New York in 2010, Judge Shendlin has again done the courts a great service by laying out a careful analysis of spoliation and sanctions issues in electronic discovery. The focus of pension committee was on when negligent failures to preserve, collect, and produce documents, including electronically stored information and discovery, may justify a severe sanction in the form of adverse inference instruction. Unlike pension committee, the present case does not involve allegations of negligence in electronic discovery. Instead, this case involves allegations of an intentional destruction of electronically stored evidence, but there are some common analytical issues between this case and pension committee that deserve brief discussion. A, the source of authority to impose sanctions for loss of evidence. Allegations of spoliation, including the destruction of evidence and pending or reasonably foreseeable litigation, are addressed in federal courts through the inherent power to regulate the litigation process if the conduct occurs before the case is filed, or if, for another reason, there is no statute or rule that adequately addresses the conduct. See Chambers v. NASCO, Inc., 1991. If an applicable statute or rule can adequately sanction the conduct, the statute or rule should ordinarily be applied with its attendant limits rather than a more flexible or expansive inherent power. Rule blah 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 37B provides if a party or a party's officer, director, managing agent, or a witness designated under 30B or 31A fails to obey an order to provide or permit discovery, including an order under 26F, 35, or 37A, the court where the action is pending may issue further just orders. In addition to what I cited from the Rules of Civil Procedures, 37B, a court has statutory authority to impose costs, expenses, and attorney's fees on any attorney who so multiplies the proceedings in any case unreasonably and vexatiously. An alleged spoliation and proposed sanctions in this case implicate the court's inherent authority, including for spoliation occurring before this case was filed or before discovery orders were entered, and Rule 37 for failures to comply with discovery orders. Interesting. So, implicate the court's inherent authority. Interesting. B, when deletion can become spoliation. So what was A? The source of authority to impose sanctions for loss of evidence. Now we've moved into B, when deletion can become spoliation. Spoliation is a destruction or the significant and meaningful alteration of evidence. Electronically stored information is routinely deleted or altered, and affirmative steps are often required to preserve it. Such deletions, alterations, and losses cannot be spoliation unless there is a duty to preserve the information, a culpable breach of that duty, and resulting prejudice. Generally, the duty to preserve arises when a party has noticed that the evidence is relevant to litigation or should have known that the evidence may be relevant to future litigation. Generally, the duty to preserve extends documents or tangible things. Defined by the Federal Rules of Procedure 34, by or to individuals likely to have discoverable information that the disclosing party may use to support claims or defenses from Zubalaki 4. So, I want to say that's a rule, kind of the rule on spoliation. Culpability, Part C. Part D is relevance and prejudice, the burden of proof, and Part E is remedies, adverse inference instructions. Let's see here, before we move to the next section. So for culpability, as a general rule in this circuit, the severe sanctions of granting default judgment, striking pleadings, or giving adverse inference instructions may not be imposed unless there's evidence of bad faith. Mere negligence is not enough to warrant an instruction on spoliation. So this is a rule in of itself, but it comes from case law, which is Russell versus University of Texas of Permian Basin. Quoting Vic of Texas Employment Commission. So this is all Texas precedent. Other circuits have also held negligence insufficient for an adverse inference instruction. The 11th Circuit has held that bad faith is required for an adverse inference instruction. The 7th, 8th, 10th, and D.C. circuits also appear to require bad faith. The 1st, 4th, and 9th circuits hold that bad faith is not essential to imposing severe sanctions if there is severe prejudice, although the cases often emphasize the presence of bad faith. In the 3rd Circuit, the courts balance the degree of fault and prejudice. So this is an analysis. I don't know what to call it. Peer analysis. The court in Pension Committee imposed a form of adverse inference instruction based on a finding of gross negligence and preserving information and collecting it in discovery, which is being asked for here. Adverse inference jury instructions. Based on a finding of gross negligence. The court applied case law in the 2nd Circuit, including the Language and Residential Funding Corp. Versus the George Financial Group in 2002, stating that the sanction of adverse inference may be appropriate in some cases involving the negligent destruction of evidence because each party should bear the risk of its own negligence. That language has been read to allow severe sanctions for negligent destruction of evidence. In the 5th Circuit and others, negligent as opposed to intentional bad faith destruction of evidence is not sufficient to give an adverse inference instruction and may not relieve the party seeking discovery of the need to show that missing documents are relevant and their loss is prejudicial. So bad faith destruction of evidence is not necessary. It may not relieve the party seeking discovery of the need to show. Okay, so there is a burden of proof on, I want to say, the movement. The circuit differences in the level of culpability necessary for an adverse inference instruction limit the applicability of the Pension Committee approach, and to the extent sanctions are based on inherent power, the Supreme Court's decision in Chambers may also require a degree of culpability greater than negligence. Relevance and prejudice, the burden of proof. It is well established that a party seeking the sanction of an adverse inference instruction based on spoliation of evidence must establish that 1. The party with control over the evidence had an obligation to preserve it at the time it was destroyed. 2. The evidence was destroyed with a culpable state of mind. And 3. The destroyed evidence was relevant to the party's claim or defense that such a reasonable trier of fact could find that it would support the claim of evidence. So this is Subulaki 4. The relevance and prejudice factors of the adverse inference analysis are often broken down into 3 subparts. Whether the evidence is relevant to the lawsuit, whether the evidence would support an inference sought, and whether the non-destroying party has suffered prejudice from the destruction of the evidence. There's a lot annotated from that. In Pension Committee, the court followed the approach that even for severe sanctions, relevance and prejudice may be presumed when the spoliating party acts in a grossly negligent manner. When the level of culpability is mere negligence, the presumption of relevance and prejudice is not available. The Pension Committee court impose a limited burden on the innocent party to present some extrinsic evidence. Which is what I had just said. The 5th Circuit has not explicitly addressed whether even bad faith destruction of evidence allows a court to presume that the destroyed evidence was relevant or its loss prejudicial. In case law in the Fifth Circuit indicates that adverse inference instruction is not proper unless there is a showing that the spoliation evidence would have been relevant. In the present case, the party seeking sanction for deleting emails after a duty to preserve have risen, presented evidence of their content. The evidence included some recovered deleted emails and circumstantial evidence and deposition testimony relating to the unrecovered records. There is neither a factual nor legal basis nor need to rely on a presumption of relevance or prejudice. Is that because they're relevant? There's neither factual nor legal basis. Okay. It's not an element in the Fifth Circuit. Is this the Fifth Circuit? Remedies, adverse inference instructions. Courts agree that a willful or intentional destruction of evidence to prevent its use in litigation can justify severe sanctions. Courts also agree that the severity of a sanction for failing to preserve when a duty to do so has arisen must be proportionate to the culpability involved and the prejudice that results. Such a sanction should be no harsher than necessary to respond to the need to punish or deter and to address the impact on discovery. A measure of the appropriateness of a sanction is whether it restores a prejudiced party to the same position he would have been in absent the wrongful destruction of evidence by the opposing party. That's what they're looking to do. Next page. We're going to be done this case. We're not going to be done this case. Okay, we're going to be done this case in a couple pages. Style in the class. Extreme sanctions, dismissal or default have been upheld when the spoliator's conduct was so egregious to the amount of forfeiture of his claim and the effect of the spoliator's conduct was so prejudicial that it substantially denied the defendant the ability to defend him. Books. Thank you. When a party is prejudiced, but not irreparably, from the loss of evidence that was destroyed with a high degree of culpability, a harsh but less extreme sanction than dismissal or default is to permit the fact finder to presume that the destroyed evidence was prejudicial. Rimkus motion for sanctions and contempt. 9, 10, 2, 6, 6, 6, 7. The parties' contentions part A. A1. The duty to preserve is on the following page. But for A, the parties' contentions, Rimkus argues that the defendants intentionally deleted emails in direct contravention of their legal duty to preserve electronically stored information, which they anticipated when would be engaged. Nine, 10, 264, 26679. That's not right either. You have to be like this. 2641 6679. Really? 910 2641 6679. Rimkus contends that the duty to preserve arose before November 2006 when Bell, Cammarata, and DeHard planned to sue Rimkus in Louisiana. Rimkus points to the November 11, 2006 email that Bell sent to Cammarata, DeHard, and Janowski, stating that they need to file a suit in Louisiana and serve Rimkus on Monday to prevent them from filing in Texas. Rimkus argues that the defendants understood that their Louisiana suit seeking to invalidate the non-competition and non-solicitation clauses would be met with a countersuit seeking to enforce the provisions as well as the contractual and common law duty not to misappropriate proprietary and confidential information. So this is the notice. Fact. Rimkus alleges that the defendants schemed to destroy evidence showing the extent to which they took confidential information from Rimkus to use to set up, operate, and solicit business for U.S. Forensic. The scheme and the attempt to conceal it included deleting emails showing that the defendants took information from Rimkus and used it for the U.S. Forensic, donating or throwing away laptop computers from which such emails might be recovered, and lying about personal email accounts. According to Rimkus, the cover-up unraveled when DeHart testified about the defendant's agreement to delete all emails more than 2 weeks old. Rimkus also points to the April 2008 email Gary Bell sent himself containing attachments with confidential Rimkus customer contact information and the reports Cammarata produced containing language and data copied from Rimkus. Rimkus argues that the documents withheld from production until recently, combined with Cammarata's and Bell's prior testimony, provide evidence of intentional bad faith efforts to withhold or destroy relevant information. As a sanction for spoliation, Rimkus asked this court to strike the defendant's pleadings and enter a default judgment, or, in the alternative, to give an adverse inference jury instruction at trial. Rimkus also seeks reimbursement of the costs and fees incurred in discovering or attempting to discover spoliated evidence and movement for sanctions. 1. Duty to preserve. The record shows that no later than November 11, 2006, when the defendants were about to preemptively sue Rimkus, they had an obligation to preserve documents and information, including electronically stored information relevant to these disputes. The disputes included whether Bell breached the fiduciary duty he owed Rimkus as an officer, whether Bell or Cammarata breached enforceable obligations under the non-compete and non-solicitation provisions in the parties' contracts, and whether Bell or Cammarata breached contractual and common law duties not to take or use Rimkus's confidential and proprietary information. Is this the notice?
This is question. Yes. What classes were taking next?
Bell sought the advice of counsel before leaving Rimkus. The November 11, 2006 email from Bell to Cammarata to Hart and Janowski discussing the final steps of the plan to sue Rimkus in Louisiana to challenge the non-compete and non-solicitation provisions shows that the defendants knew that they would be suing Rimkus within days. The duty to preserve electronically stored information documents relevant to that suit and reasonably anticipated related litigation was triggered no later than November 11, 2006. The defendant's argument that their preservation obligation was limited to documents or emails related to breach of duty obligation claims against Bell is unpersuasive. Bell, Cammarata, and DeHard sued Rimkus in Louisiana seeking a declaratory judgment, and the non-competition and non-solicitation clauses were unenforceable, so they could operate U.S. Forensic to compete with Rimkus. It was reasonable for Bell and Cammarata to anticipate that Rimkus would seek to enforce his contractual provisions as to all the U.S. forensic employees who left Rimkus, as well as the contractual and common law duty not to disclose Rimkus's confidential and proprietary information. Emails and attachments and other documents relating to U.S. Forensic and its related company to soliciting Rimkus clients or employees and to obtaining or using Rimkus's information are subject to a preservation obligation. Such records are relevant to the claims relevant. I wonder why they go through this relevant analysis when it said that that the presumption didn't even come into the issue. So anyway, they were relevant, involving Louisiana state court action at Cammarata, Bell, and DeHart filed, and to the reasonably anticipated claims that Rimkus would file and involve the key players of the parties' litigation. Rule 37E, which precludes sanctions if the loss of information arises from the routine operation of the parties' computer system, operated in good faith, does not apply here. The evidence in the record shows that defendants and other U.S. forensic founders did not have emails deleted through the routine good faith operation of the U.S. forensic computer system. DeHart testified that he, Bell, and Cammarata and Janowski decided on a policy, so this is kind of a fax, of deleting emails more than 2 weeks old, putting aside for the moment other evidence in the record inconsistent with this testimony. A policy put in place after a duty to preserve has arisen that applies almost exclusively to emails. Subject to that duty to preserve is not a routine good faith operation of a computer system. Moreover, the evidence shows that the founders of U.S. Forensic manually and selectively deleted emails. Policy to put into place to preserve applies almost exclusively to emails. It's not a routine good faith operation of computer system. Rimkus filed suit in January and February 2007. Despite the fact that the founders of U.S. Forensic had sought and obtained legal advice on many aspects of their departure from Rimkus and their formation and operation of the competing business, they made no effort to preserve relevant documents even after the Louisiana and Texas suits had been filed. To the contrary, the evidence shows affirmative steps to delete potentially relevant documents, even assuming that they was an email destruction policy, as DeHart testified. It was selectively implemented. The deleted documents include emails and attachments relevant to disputes from Rimkus and emails and attachments showing the information the founders took from Rimkus was used in competing business, including the solicit business from Rimkus clients and how they solicited those clients. The record shows that the electronically stored information that the defendants destroyed or deleted after the duty to preserve arose was relevant to the issues, including both Bell and Cammarata, not limited to the breach of fiduciary claim against Bell. The deleted emails and attachments related not only to setting up the U.S. Forensic, but also to obtaining information from Rimkus included copyrighted materials, financial documents, and customer lists, using at least some of that information to operate U.S. Forensic in competition with Rimkus and soliciting business for U.S. Forensic. The evidence shows that by deleting emails relating to forming U.S. Forensic and to using information from Rimkus for U.S. Forensic, by failing to preserve such emails and by giving away or destroying laptops with such emails, the defendants destroyed potentially relevant evidence. To the degree of culpability, destruction or deletion of information subject to the preservation obligation is not sufficient for sanctions. Bad faith is required. A severe sanction such as a default judgment or an adverse inference instruction requires bad faith and prejudice. What, in this jurisdiction? The defendants proffered reasons and explanations for deleting or destroying the emails and attachments are inconsistent with and lack record support. Bell testified that he deleted emails for space concerns. Janowski testified that he deleted emails on a weekly basis because he got a lot of emails and they fill up his box. And DeHart testified in his first deposition that he deleted emails on an ad hoc basis because he was concerned with storage capacity in his inbox. So these depots, they're saying, lied. The defendants also asserted that they deleted emails about preparations to form U.S. forensic in fear of retaliation by Rimkus, and they ended up staying on at Rimkus. Alan Bostic, the IT consultant, testified the lack of space on the U.S. server and external hard drives did not become an issue until late 2007. Well after this litigation began, the fact that DeHart did not reveal a policy of deleting emails more than 2 weeks old after Rimkus was able to subpoena DeHart's Yahoo account is another reason for questioning the truthfulness of this explanation. Fear of retaliation by Rimkus might explain the deletions that occurred before the defendants resigned, but not after. Some of the emails the defendants deleted were obtained from a Rule 45 subpoena issued to one of the internet service providers, Homestead. Wow. These emails show the defendants making preparations to form U.S. forensic in September, October, and November 2006 and soliciting clients with whom they worked while at Rimkus in late November and early December 2006. Other emails obtained from the defendants, but through forensic analysis of the laptop Bell used at Rimkus, show that Bell downloaded and transmitted financial spreadsheets for specific Rimkus offices after its resignation. Emails obtained from Homestead show that Cammarata forwarded language in Rimkus reports from his home email account to his U.S. forensic email account. Cammarata admitted giving the language from a Rimkus report to a U.S. forensic associates engineer for use on project. Still another email from Bell to himself, which the defendants did not originally produce with the attachment, shows that Bell was in possession of Rimkus contact information in April 2008. The evidence that the defendants knew about the litigation with Rimkus when they deleted the emails for inconsistencies in the explanation for deleting the emails and failure to disclose information about the personal email accounts that were later revealed as having been used to obtain and disseminate information from Rimkus, and the fact that some of the emails reveal what the defendants had previously denied, that they took information from Rimkus and used at least some of it in competing with Rimkus, support the conclusion that there is sufficient evidence for a reasonable jury to find that the defendants intentionally and in bad faith deleted emails relevant to setting up the company to obtain information from Rimkus and using it for U.S. forensic and to solicit Rimkus clients to prevent the use of the emails. And there you go. So I feel like they just built up to this. Relevance and prejudice, part 3 of Section A. Despite the evidence, parties' contentions, despite the evidence of spoliation and efforts to conceal it, the record also shows that Rimkus was able to obtain a significant amount of evidence between the records independents had produced, the deleted records Rimkus obtained from the other sources, and other evidence of the contents of deleted records. Rimkus has extensive evidence it can present. The evidence of the contents in the lost record shows that some would have been favorable to Rimkus. There is prejudice to Rimkus, but it is far from irreparable. Rimkus' demand that this court strike the defense pleadings and enter a default judgment is not appropriate. The sanction of dismissal or default judgment is appropriate only if the spoliation or destruction of evidence resulted in irreparable prejudice, and no lesser sanction would suffice. Although a terminating sanction is not appropriate, a lesser sanction is of a form of adverse inference instruction is warranted to level the evidentiary playing field and sanction the improper conduct. The evidence of the contents of the deleted emails and attachments show that deleted and unrecoverable emails and attachments were relevant and that some would have been helpful to Rimkus. The emails that have been recovered by Rimkus, although great effort expense, include some that support Rimkus' claims, contradict testimony. The defendants gave and are unfavorable to the defendants. Rimkus has shown that it has been prejudiced by the inability to obtain the deleted emails for use in the litigation. To level the evidentiary playing field and to sanction the defendant's bad faith conduct, Rimkus is entitled to a form of adverse inference instruction with respect to deleted email. At the same time, it is important that Rimkus has extensive evidence to use in this case. And some of the emails that the defendants deleted and that were later recovered are consistent with their positions in this lawsuit and helpful to their defense. Given this record it is appropriate to allow the jury to hear the evidence about the deletion of emails and attachments and about discovery responses that concealed and delayed relevant deletions. The jury will receive a construction that in and after November 2006, the defendants had a duty to preserve emails and other information they knew was relevant and anticipated pending litigation. If the jury finds the defendants deleted emails to prevent their use of litigation with Rimkus, the jury will be instructed that it may, but is not required to infer that the content of the deleted emails lost would be unfavorable to the defendants. In making this determination, the jury is to consider the evidence about the conduct of the defendants in deleting emails after the duty to preserve had arisen and evidence about the content of the deleted emails that cannot be recovered. The record also supports the sanction of requiring the defendants to pay Rimkus the reasonable costs and attorneys required to identify and respond to the spoliation.
Was preparing their financial statements.
Well, that's a financial statement one.
Yeah.
Right, but it wasn't about litigation, right? It was about putting together a list of what might be outstanding debts.
Rimkus has spent considerable time and money attempting to determine the existence and extent of the spoliation hampered by the defendants' inconsistent and truthful answers to questions about internet accounts and retention and destruction of parties. The defendants failed to produce documents in compliance with court orders. Rimkus also expended significant time and effort to obtain some of the deleted emails and attachments. Conclusion: there is evidence in this record showing that the defendants intentionally deleted emails after a duty to preserve had clearly arisen. There is evidence in the record showing that at least some of the lost evidence would have been relevant and favorable to Rimkus's case. The loss of the evidence prejudiced Rimkus, not irreparably. These failures have imposed significant cost to the parties and the court. Sanctions are appropriate. Accordingly, the court will allow the jury to hear the evidence of the defendant's deletion of emails and attachments and inconsistent testimony about the emails, the concealment of email accounts, and the delays in producing records and information sought in discovery. The jury will be instructed that if it decides that the defendants intentionally delete the emails, prevent their use of litigation against Rimkus, the jury may and need not instruct that decides that defense intentionally delete emails and prevent their use in litigation against Rimkus, the jury may but need not infer that deleted emails that cannot be produced would have been adverse to the defendants. Rimkus is also entitled to an award of attorney fees and costs reasonably incurred and investigating the spoliation, obtaining emails from third-party subpoenas, taking additional depositions of Cammarata and Bell, and moving for sanctions based on the deleted email and on Bell's false testimony.
One of the cases, and maybe they wanted the list because they wanted to see other cases that could claim the same thing.
Yeah.